Yuga Labs, the parent company of the Bored Ape Yacht Club NFT project, has now reached a settlement with Thomas Lehman, who built websites and smart contracts for Ryder Rip's copycat project, RRBAYC. Joining us now is Lightman Law PLC Managing Partner David Lightman. Thank you, David.
Good morning.
Good morning. Okay, so let's just sort of break this down. So Rips' project is a series of 10,000 NFTs that share the same names and features and traits as Bored Ape Yacht Club's NFTs, and is part of a separate ongoing court case around trademark infringement. So can you just break down what the settlement means?
Well, as far as I can tell, what occurred is the plaintiff, the Yuga Labs in this case, brought a separate case against the web developer who assisted in the Ryder Rips project for the purpose mainly of obtaining evidence against Ryder Rips. And so it seems like the settlement was geared towards getting the cooperation of the defendant in the case.
So this specifically then was kind of this is sort of the preliminary thing for what they ultimately want to do, which is to go after Ryder Rips, correct? That's the ultimate goal.
Yes, there's a pending case this case was in New York. There's a pending case in California against Ryder Rips relating to the underlying issues in the case, which is not so much whether or not he copied the Bored Apes themselves, the images, but whether or not he used the Yuga Labs logos and name of the Bored Apes to sell his own products.
And so that's why ultimately this was sort of a settlement and not a straight up lawsuit, because ultimately the real lawsuit is to come, like the actual thing, and they think they believe they have a very strong case here, correct?
Correct. In that case, the case against Rips was filed in June of last year in California, and the judge in that case determined that the works at issue were not artistic works, which might merit some different kind of test in trademark law than if it was just pure commerce. And the reason for that is because Yuga Labs very carefully crafted its complaint only to complain about the use of its name and the use of its logo, and not the underlying art for the apes themselves. And the reason for that is it's very controversial under copyright law, because the Bored Apes are generated by artificial intelligence and not by humans, even though there are some human inputs instructing AI what to do. You're not entitled to copyright the underlying images if they're created by AI. So they crafted it solely as a trademark claim, because what Rips was doing, or is still doing perhaps, is really trying to trade on the name by calling, his RRBAYC for Bored Ape Yacht Club, right? And when you look at how he's promoting and advertising them, it might say RR in little small letters and then BAYC in big letters, and they have the skull logo all over their materials where they're promoting their own NFTs. So again, the court in California said at the very preliminary, part of the case, this is not a case about artistic expression the way, for example, the Meta Birkins case that's about to, have a jury verdict in New York, is about whether or not the Meta Birkins created by that creator are in fact, protected artistic expression.
So do we know that whether or not the AI code was used in the RBAYC as well? I mean, is that something that they could potentially sue on, the use of the underlying AI code, if you will, to generate those images, or is that something that they can't?
It's not specified in the complaint, but it seems like what Rips did was to simply right-click on the images, from the NFTs and just copy them, which is, a feature, unfortunate feature of NFTs, and somewhat drives their their value, having gone down quite a lot after the initial popularity of them.
So this is such an interesting topic. NFT trademark law is so new, right? And there's still so many questions. So what I understand what you're saying here is that like the issue was more that they were using like sort of Yuga labs. That was sort of the protected thing. And then for the actual apes themselves, you said that they're generated by AI, so that protects them to some degree. But what if they weren't? Like, how does it just work for your average NFT? Because the NFT community always sort of makes it sound like, I don't know, they don't make it sound like anything. It's very confusing. But like, because you see when somebody buys an NFT, there's a certain part of the crypto community that says, oh, whatever, I have this NFT, you can copy it and use it indefinitely, but I'm the one who owns the original one, so it doesn't matter. So it's kind of in this weird wild west of copyright and trademark. Like, how does it work for the actual images? If they weren't generated by AI, would that matter? I mean, would they be protected? Or I just don't understand how trademarks even work here.
Right. So, for example, I have a client who's a photographer who's taken his own celebrity images and made derivative works of those by, altering them himself, and then he intends to sell NFTs. And so we're in an area here where, again, the courts haven't really fully explored this, but in the old days of just selling a piece of art, or a photograph, right? For example, you could sell a physical version of it, right? You could put it in a gallery and sell it in a gallery, or you could sell prints and mail prints to your customers. Or you have the copyright interest, which is the right to copy it, for example, and transmit it electronically. An NFT is neither of those things. An NFT is sort of a property right, and the way I sometimes explain it is, it's like as if you had a cell on a spreadsheet that says, I own this cell X15, and in the X15 cell it says who owns the NFT, and it's something that's tradable like a stock or a security, which is why the SEC thinks that the trade and sale of certain types of NFTs are more like securities. I can trade the ownership right in that cell, but trading the ownership right in that cell does not either entitle me to sell a physical good or to sell the copyright in the piece of art. The copyright remains with the owner of the art, and the physical good owns with whoever the art was sold to under the first sale doctrine. You can then resell the painting or photograph that's hanging on your wall. So it's really sort of a different trading system. And, I saw yesterday there was an article about a lot of people are using their NFTs as collateral for loans to, buy cryptocurrency. They're buying cryptocurrency using their NFT ownership as collateral. And so really what we have here, it's sort of a digital right, but it's not an intellectual property right. It's just a right, just like you could own 5 shares of IBM, and you can sell those on a trading market. Okay,
so you're saying Yuga Labs would have the digital art right. The owner of the NFT would have ownership over the cell, and that's kind of how it distributes. But separately, you also mentioned the trial between NFT artist Mason Rothschild and French luxury house Hermes. And their trial came to a close on Monday after a year-long trademark battle over an NFT project inspired by the brand's famous Birkin handbags. And the jury is expected to reach a verdict by this week. Maybe you can go over some of the differences. And you said in this case, this is the artist, at least, is saying this is art, and it's not just copy and paste of a Birkin bag or a photo of a Birkin bag, but there was some artistic expression and license. And I wonder what's the standard for that to make that valid in a legal space.
Sure. And so, what you can see, you just showed on the screen what the Meta Birkin's NFTs look like. And so what they essentially did was they took the shape of the Birkin bag that Hermes is famous for. They covered them in fur electronically. They didn't use actual fur, I don't believe. And then they sold them as NFTs, like these, cells in an Excel spreadsheet that I'm talking about. And so again, they didn't sell a physical good. They didn't sell a bag. They didn't sell prints of the art. They just sold it as an NFT. And the question then becomes, since they're not exact copies of the Birkin bags, and they're artistically derivative of the Birkin bags, is what rights does Hermes have? And so in this instance, they're using the word meta Birkin, right, to convey that it's some kind of art in the metaverse, right, that is akin to the Birkin bag. And so the issue in that kind of situation, right, where again, we're not talking about copyright law, we're talking about trademark law, is whether or not the artist, even if it's art, is using the name Birkin and the shape of their bag, which Hermes has a trademark over, whether they're using it to explicitly mislead consumers as to the source of the product. And what we have is a situation where when it first came out, there were a number of articles that said Hermes is creating NFTs with their new Meta Birkins, right? Which shows at least that some people were confused. In response to that, what the artist did was he put a disclaimer on the NFTs saying that it had, Hermes was not the source and they had no association with Hermes, and they reached out to the various press articles, the publishers of those publications, and asked them to print retractions. And the question is whether that was enough or not. And what the judge expressly said was, this is a question for a jury, because there were emails and communications from the artist basically talking about trading off of the goodwill of Hermes in order to sell his NFTs, which would show an intent to mislead the public. And so whether or not the consumers and the relevant consumers here would be consumers of Hermes bags, right, who generally are pretty sophisticated, wealthy, individuals. And the question is, were they really going to be confused by the NFTs, the Meta Birkins, whether or not that relevant consuming audience for Hermes's products would be confused by the defendant's works? And the judge said, that's not something a judge can decide, that's something a jury has to decide. So the jury started deliberating yesterday afternoon, and everybody in the intellectual property community is at the edge of their seats waiting for the verdict, which may come as early as today.
Jane Birkin doesn't have a case, does she?
No. No.
We're on the edge of our seat as well. David, thank you for that fantastic explanation, breaking down the law for us. That's Leichtman Law Managing Partner, David Leichtman.